Well, hello and good afternoon. Welcome to Snyder Law Live, Nuggets of Knowledge. I'm your host, Kevin Snyder of Snyder Law. We are an estate planning firm in Irvine, California, and I'm here today to provide a little bit of insight as to why you want to avoid probate. So hopefully you brought some great questions with you. Let's sit back, enjoy your lunch, relax, and hopefully you'll find a lot of great value out of what I'm going to say. So today, we're going to talk about the top 5 reasons you want to avoid probate. I bring this up because probate is a word that's out there that people sort of realize, the conventional wisdom, is that it needs to be avoided. But as I was having a conversation with a neighbor fairly recently, and I was talking about estate planning, he had some questions, and he mentioned how he wanted to avoid probate, and I just kind of gently asked, well, do you know why? And he said, well, that's because George told me to. And I thought, well, that's great information. George is right, but the point is that we all hear that we should avoid probate, but do we know why we should avoid probate? So allow me to provide a little insight here. So I called this the top 5 reasons. There are probably more than 5. We're going to hit some of the highlights. So probate, what does that mean? Well, the government has rules for you when you die or when you become incapacitated. And probate court, generally, in our common use of the word, we are referring to what could happen if you die without drafting any sort of estate planning, such as a will or a trust. We die without any planning at all. That's called dying intestate. And so a lot of times when you hear probate, or we need to avoid probate, or I want to avoid probate, that's what we're referring to, the court process that follows after you die without having any planning done. I want to just take some time right now to make a quick point because this isn't something that I find is very widely known, but it's important. While dying without a plan is called dying intestate, you will certainly, your estate, all the things that you own, will end up in this court process called probate. But all your stuff will also end up in the probate process if you die by simply drafting a will, or when you draft a will, and that's what you have as estate planning, a will also gets probated. So if you're looking to avoid probate, doing a simple will planning is not going to meet that goal. And I'll explain more as we go forward. So probate is the court process that is followed after a person passes away and they have assets or things that they own, their stuff that's in what's called their probate estate. And there's also another court process in probate, and I call this probate 1 and probate 2. Probate 1 is the process that we just talked about. It happens after a person passes away. Probate 2 is a process that happens when a person is very much alive, they just are an unsound mind, meaning that they don't have the ability or capacity to be making decisions about their finances or themselves. And they end up in probate court as well in what's known as a conservatorship. This is probate 2. But today we're going to be talking about probate 1. Probate 2 is a whole other conversation that we'll have in the future in another lunch. So be sure to watch out for that. So the situation of probate 1, a person has passed away, they haven't done any sort of estate planning. What is the process? What does that mean? Well, it's a court process. In order to hand off your stuff, your things, to your heirs, the people in your family that are legally entitled to inherit, a certain court process has to be followed. The court has to determine what it is that you own, who's going to be the executor or personal representative, they're synonymous, who's going to be in charge of administering this through the court process, and who are your heirs going to be, and who are your creditors, who's owed money. And the court marshals through this ongoing process that has deadlines and certain benchmarks throughout to figure out what you own, who you owe, and who's going to inherit. And all of that takes time. And that is why, one of the reasons why people want to avoid probate, because it's lengthy. And I'll show you in a moment a graph that puts all this forward. So that's the court process, and that's what probate is. A judge sits and reviews any sort of will or estate documents. The court appoints somebody to administer your estate. That's your executor or personal representative. And the court oversees the collection of the things that you own, the itemization of it, and the court oversees any payment of debts that's owed and approves the final distributions to your heirs. It's also a place for the court to receive any sort of challenges to the distribution of your estate or debts or anything of that nature. That is the court process. And it happens in the county in which you resided at the time that you passed away. And it begins with the filing of a will, if you have one, or a petition by the person who wishes to be your executor. That's the court process. But why do we want to avoid this court process? If anyone's been to court at all for anything, you realize that it's not a very quick process. It's not your time, it's court time. You're not in control, the court is in control. So these are all reasons why we want to avoid court. But here's something that's a little bit, that expresses this in a little bit more clarity. I'm going to try to share something with you in a moment. I don't know if I can do this, but I call the probate process the probate grinder. And why do I call it the probate grinder? I call it the probate grinder because this is a process that takes all of your assets together and grinds them up, and at the end of it spits out some money for taxes, spits out money for fees, and at the end of the day what's left over, which is a smaller amount, is the inheritance to your loved ones, your family, those that you intended to be heirs. And that's why it's called the probate grinder. In that process, it's lengthy. We can expect 12 to 18 months, so there's a lot of time delay. You've lost control because you're no longer around, and the court has the final say-so as to what happens. Sometimes that leads to unintended consequences. For example, if a person has passed away and they haven't finalized a divorce, or a person's passed away and their legal heirs, all of whom they don't have a current relationship with, they wouldn't be somebody that they would have left an inheritance to. These are all unintended consequences. Also not in control is the use of those assets. They're frozen for the period of time that is going through probate, with the exception that the court can make for allowances and access to some assets for emergency funds throughout the court process, but you have to go to court to request, and it's not a given. It's not as easy as if the accounts and the assets were available like they were before. So we have delay. We have lack of control. We also have the fact that there's no asset protection. And what do I mean by that? Well, at the end of the day, when the court decides who gets what and actually gives that over, that's called a distribution. That distribution is given outright. Outright is no different than if somebody wrote a check and gave it to you and you cashed it at the bank. Or as I like to refer to in the probate court, it's like when you win the sweepstakes and they're knocking on your door, you get this big check. And you are able to use that money unperturbed. You use it or lose it as may happen. And I point that out because your beneficiaries, your heirs, the people that you ultimately want to receive an inheritance from your estate are going to receive that inheritance, but they might be going through a divorce, they might be going through a bankruptcy, they could be embroiled in a lawsuit. All things that are creditors and predators to that inheritance. Your intended heir, your family member, for example, your loved one, your friend, whoever it is, that inheritance could be taken from them because it gets swallowed up in that lawsuit, divided in half in the divorce, potentially, and also taken as damages in the lawsuit or the bankruptcy. So it's a way that that inheritance could be lost. And of course, it could be misused. If it goes to an heir that isn't a good steward of finances, doesn't do a good job with their money and investing it, it could be used very quickly and not for its intended benefit. So it could be used or lost as may happen. So there's no asset protection there. With different types of planning, for example, with setting up a trust, you can incorporate some asset protection in the gift of your inheritance, but you can't do that here. Another way that comes up, that's a problem, is if your intended beneficiary, your heir, is somebody who has a disability that's receiving need-based government benefits. A receipt of an inheritance through the probate process could cause them to become disqualified for that benefit. So that's something to be considered. If the person is receiving some sort of financial aid through school, grandma leaves Johnny an inheritance or through her will, or doesn't do any estate planning, and Johnny, her grandson, ends up being an heir and receives some money. If he's receiving financial aid from his college, then he could be disqualified for that financial aid in the future, or not qualify, because now he has received a larger asset. So those are also unintended consequences through this outright distribution with no asset protection. There's also what I call the 18-year-old problem. And what do I mean by that? Well, the same scenario, if your heirs are individuals that are minors, they're under 18. This could be your children, this could be your grandchildren, and they end up being deemed to be your beneficiaries of your estate or a portion of your estate. They can't receive it if they're under 18 because they're not of majority age, they're not adults. So what happens? Well, the court appoints a financial guardian to oversee their interest and they manage that inheritance until they turn 18. And on their 18th birthday, then they're legally entitled to their inheritance outright. Remember that sweepstakes example I gave. Imagine if on their 18th birthday, the court's knocking on their door and is giving them that big sweepstakes check. And that could be a very large portion of your estate, depending on what you have and how much it's going to be divided up amongst your heirs. And I don't know about you, but when I was 18, really anything over $100 probably would have been misused or gone very quickly. And that's because 18-year-olds, while even the smartest of them, those that are going off to great schools, straight A students, just aren't ready to handle that type of inheritance wisely. It also attracts negative attention. People find out that you receive an inheritance, you're all of a sudden attracting people that want to tell you how to use it or convince you to do certain things with it. In fact, there are people that troll public dockets through the probate court because it is a public venue, another downside, that look to try to swindle funds out of heirs that are vulnerable, whether they're older or they're younger heirs. So it's something to be considered right there. That's an 18-year-old problem. And last is the cost. The cost of probate is expensive. Why is it expensive? Well, it's expensive because there are certain fixed fees, and this isn't negotiable. It's built into the code here in California. There is a schedule of fees depending on the fair market value of the things that you own, and you can look at that schedule in the probate code, and you can come up with a calculation. But I'll give you an easy multiplier. So everyone at home right now, you can write down, do this exercise. Do it tonight with your spouse. You can sit down, write down all the things that you own, and right next to it, write down the fair market value of those items. When I say fair market value, I don't mean what equity is in them. What do I mean by that? Well, commonly I'm approached by people and they ask me, well, do I need to do any estate planning because I have a high mortgage on my home? And their question is geared along the lines of, because I don't have any much equity in my home, do I really need to do planning? And the answer is yes, you do, because the probate court, in determining their fees, for example, don't look at how much equity you have in your home. They look at the fair market value of your home. And here, we are blessed or cursed in Southern California to have high home values. So if we have a high mortgage, well, they're looking at the fair market value. What would your home sell for at the time that you die? And that's what they use to determine your value and of that property. With bank accounts is a little bit easier. Whatever is in your accounts and investment accounts, what's the value on the day that you die as far as those investment accounts, so on and so forth. Add all those things up. That's the fair market value of all the things that you own, your estate. And the probate court will charge a fee, basically. The multiplier is 5%. So do that exercise, add up everything you own, multiply it by 5%. That is a rough ballpark of what the probate fees are going to be in your estate. And it could be less. There are some variables at play here, whether you have some assets that are going directly to beneficiaries like life insurance or retirement accounts. Also, if your executor takes a fee for their services or not. But certainly if an attorney is assisting, there's going to be fees that are paid out on this percentage basis. So worst case scenario, you take that multiplier, take 5%, and that'll give you a rough ballpark, and it's a hefty fee. As you'll see, there are those funds could be used a lot more efficiently towards benefiting your loved ones and your family. So to recap, what are the 5 pitfalls or the 5 reasons to avoid probate? Well, 1, it's a lengthy process, 12 to 18 months. 2, you're not in control, the court's in control, and assets are frozen in the meantime. 3, it's a public venue, which means that people can see what's in your estate, and that gives rise to some conflict sometimes amongst family members, or also attracts some potential creditors that are out there that may have been forgotten. It creates a venue for litigation. 4, you have no asset protection for your loved ones, your beneficiaries. They receive things outright, which is subject to any sort of creditors or predators taking that inheritance from them, or for them misusing it, including the 18-year-old problem where you have a beneficiary that is not old enough to manage their own money, or is not qualified to be handling that amount of money and attracting negative attention. And lastly, it's expensive. It's expensive to your estate and to your loved ones. So love to chat with you more about reasons to avoid probate and what some of the solutions are. Feel free to reach out with some of your questions. Glad to take some questions right now. If you have them, just type them right in. Glad to answer them. So give me a second. Let me see if we have any in the docket right here. Okay. Question is, well, I own a home jointly with my spouse. Doesn't that avoid probate? The short answer is yes. If you own a home as joint tenants with another person, whether it's your husband, wife, or another person, that type of relationship in ownership will avoid probate. Why? Because joint tenants with a right of survivorship means that when one owner dies, the other one immediately takes over the entire interest in that home or property. So yes, you will initially avoid probate in that scenario. However, you're just kicking the can on down the road, because what if there's a scenario where that second person who inherits the entire home, so you have a husband and wife, husband dies, wife inherits the whole home outside of probate, but then what happens when the wife dies? If she hasn't done any other planning, then that home's going to go through probate. So you're able to avoid probate in 1 step, but not 2 steps. So great question, but that is something that is often overlooked, is what happens when the second of us passes away. And sometimes it might happen at the same time, and if there's not going to be any room for or any time for any additional planning. It's a good question. So other questions? Well, doesn't look like we have any other questions. If you do have questions, please just post them on our Facebook page. Send me an email at kevin@snyderlawpc.com. Visit our webpage. We have a great blog that has a lot of these topics that have been addressed, and we have some great answers in there. Love to see you back here next week. So go ahead and like our event, like our Facebook page. Come and see us next week. We're going to be going live on Monday instead of Tuesday. Look for the notices. We're going to be covering a great topic next week. We'll be taking your suggestions and posting the event tomorrow. So if you have any great ideas for topics to cover, or you have some questions, please post them, and we're glad to turn that into a Facebook Live event for you. So go out, enjoy the rest of the week, have a successful and amazing week, and I'll see you back here on Monday. Take care.